These Creditors in Commerce workshop sessions, hereinafter sessions, are the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in these sessions, as applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transactions or that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subjects being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions, and the fact that the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. These sessions may be redistributed privately by any recipient to another recipient requesting them, condition upon the fact that this notice is provided therewith. If you have any questions, you may contact Creditors in Commerce by email at harmony@creditorsincommerce.com.
Thank you for coming to Creditors in Commerce Los Angeles workshop. Okay, seeing as we're already about 40 minutes in, I'm going to try to get through this. We've got a lot of material we're going to try to cover this weekend, even though we seem to have quite a few hours. We really try to pack it in so that you guys walk away with as much of a complete understanding as possible. That's our goal, that everybody walk away here with a competent understanding of contract and commerce. And we will also be building teams so that you'd walk away from here with a group that you will be able to work with. If your own personal remedies is something that you're seeking to resolve, then you will have a team of people to work with to resolve your problems. You don't have any problems. To assist you in resolving the IRS's problems, the mortgage company's problems, okay? You guys don't have problems. All you have is solutions. So, as creditors, we're going to teach you to solve these people's problems. We're going to teach you how to take responsibility for our community. That's why we're solving their problems. We want everyone to win. We want the government to be doing well and be healthy. We want the banks to be doing well and be healthy. And we want our communities to be doing well and healthy. So, being a creditor. Okay, the contract. This is my little offer. Go through some definitions here. A workshop is an educational seminar or series of meetings emphasizing interaction and exchange of information among a usually small number of participants. This is a small number of participants. Information, knowledge, communicated or received concerning a particular fact or circumstance. What is knowledge? The fact or state of knowing the perception of fact or truth, clear and certain mental apprehension. And a fact, a truth known by actual experience or observation. And truth, a verified or indisputable fact, proposition, principle, or the like. Now, if we look at these definitions, we kind of got a circle going here between truth and fact. What's truth?
Could it be in accordance with the facts?
It could be. Can you prove anything, Gordon?
No, I can't.
Okay.
You can. Can't you?
So, in reality, truth, in my opinion, is your experience. Everyone will take from this workshop a different experience. Each person experiences a meal differently. Each person experiences a conversation. If you and I are having a conversation, we will walk away with two completely different ideas of what transpired in that conversation. What's the truth? The truth is your experience. So whose truth is it? It's your truth. So you'll hear us talk a lot about how we don't take a position as a creditor. If we take a position, are we attempting to impose our truth on someone else?
It might help to Webster's has a nice definition for truth. That which is true. And when you go to that which is true, it says, in accordance with the facts. And each of us see the facts differently. I see myself on the left-hand side of Brandon and on your right-hand side. Yet if somebody's standing over here, they might see it. Jack will see it. No, that ain't the way it is. I saw him on my right side, not left side, whichever. So what's true to you is true to someone else. So it's kind of where Brandon tells you it is a circle. And then you go to what's true. It's in accordance with the facts. The facts are that's what is true. And what is true is whatever you make it.
And my vessel is starboard of yours, actually.
Really?
Okay, here's the offer. Can we, the participants in this exchange of information, commit to creating, communicating, and integrating the knowledge, tools, behaviors, intentions, consciousness, awareness, and support necessary to effect a change for the benefit of all living souls? I use the word all living souls because you are not persons, you are not people. You are not the body. And it's very important to understand that.
Perhaps a little elucidation?
A little elucidation?
All right. Real simply, most of us believe in God. So in oversimplification for me, if this body dies, is there a spirit inside here that goes someplace? In my opinion, there is. Therefore, what he's telling you is this is not me. It's merely the vehicle, the vessel upon which I, the spirit, the soul, travels around in. So, yes, I'm being very technical, and so does the law. So, when Brandon's telling you this isn't you, he means this is merely just the vessel. This body isn't you. And if you can think that when it dies and the spirit goes somewhere, it's easy for you to see that this, in fact, is not you. You are the spirit inside there. So if a policeman says, is this you, on a piece of paper, he has merely a picture or a likeness of this vessel that you ride around in. So he could show you the picture of your Camaro or your Ford Explorer, your Excursion, and that's not you. It's merely the vehicle that you travel around in.
Or it's merely a card with a picture on it.
The other side,
how can I be a card with a picture on it?
the other side of that issue is neither are you the name. The name is attached to the vessel or the body. And the government has registered that body to the birth certificate. So when you go into either a court or administrative proceedings, in the public, the first thing the judge will say, or the administrator, is, "Are you Jack Smith?" How can you be a name? The name is associated with the body. On death, your soul and spirit are no longer connected with that body. But that body is buried in a tomb under that name. The Spirit does not carry the name with it. The Spirit is eternal, and it is what it is. And so the trick is when you go into the proceedings and the judge or the administrator says, "Are you Jack Smith?" Jack Smith is the commercial debt account they're trying to collect. And their trick is to get you to identify in the public sector as the surety in public on that debt account. And when you answer that question, you have just deposed yourself, removing yourself as the surety in the private, which we're going to talk about later. And you've done a general appearance in the public to be a surety in the public for the public debt that they're coming after. And so you cannot answer that question without some form of reservation. If they say, "Are you Jack Smith?" you have to be able to understand how to reserve your rights so that you're not contractually agreeing in the public to be liable for that public debt.
Are you saying, Jack, that there's a private surety and a public surety that
Yeah,
we're going to later talk
absolutely,
about?
and we'll talk about that later on.
So where I'm a little confused about suretyship, I might be able to get a little more clarity later when you start explaining
Absolutely.
suretyship as it relates to the scriptures and this and that.
I was going to say, we're getting a little ahead of ourselves, but we will go into that and go into detail on those titles and names. My family, the last ones in the room. Jeez. All right. Here's some of the topics of the exchange. Principles and concepts of commerce. What I call creditor ontology, which is the beingness of a creditor. That is probably the most important stuff to get. And I will tell you about an experience I had last weekend. And that is what had me prevail. A little bit of knowledge, but mostly my being. There were no documents involved. There was no special technologies involved. There's a little bit of knowledge and being. Go a little over what I call natural law, which is kind of an interface bringing us into the law of contract. Natural law is what we could call universal law, and elements that give us the nature of our reality. Sovereignty and authority. Very important subject to understand. Contracts and trusts. Claims and administrative procedures. Liens, interest, titles, rights. Tomorrow we'll be going into mortgages and foreclosures. Private real world versus public colorable world. Banker, postmaster, judge, governor, sheriff, which is you. County, state, nation, bank, post office, court, which is your vessel, or vessels, can come in many forms. And practical application of principles and concepts. So we will take all of these things that we discuss, the principles, the concepts, some of the technologies, and then we'll show you how we've applied them. There's several people in here who have applied this information, this technology, this understanding, and these ways of being to achieve amazing things. And some of these people only have been exposed to this information for a couple months, less than a year. But they caught on. They got the being, they got the little bit of information they needed, and they're achieving great things. And we'll talk about a lot of the things we've achieved, and a lot of the things we've assisted people in achieving. Okay, now we're going to get into some principles and concepts, and we can go into who am I? Okay, a principle. I always like to give a couple definitions when we get into things so that you could get there's 3 books for me personally that are very useful in navigating through commerce. One of them is a dictionary. I would suggest a thorough, unabridged dictionary and a legal dictionary. principle. The other, let me get into the 3 books, I guess. The Holy Bible. Now, I am actually I do not prescribe to any religion. I love them all, and I learn from them all, as Eastern philosophies and religions as well as Western philosophies and religions. However, in Western culture, which commercial law and international law have derived from the Western culture, it all derives directly from the law of the Bible. And you will see, when you really look at the Bible, that there is the entire commercial and legal system lined out for you to understand how to operate as a creditor and how to operate as a debtor. And my 3rd book is Williston on Contracts. Great book.
You know, whether he's talking Williston on Contracts, Restatement Second, Brian Blum's Contracts,
Examples and
explanations, what he's really telling you is simply get a book relating to contracts that might have some examples and explanations so you can get an understanding of what contracts really are and how they operate and the nuances associated therewith. And whether it's Williston, Restatement Second, Brian Blum, and probably a half a dozen or more others that are well-versed in contract law, because contract is not a complicated subject among the erudite. It's very simple. And it shouldn't take all of you long to understand what contracts are and how they operate. And you don't have to read this whole book. But there are sections like offer and acceptance that really are relevant and relate to you. But some of the other sections have lots of nuances, and you get an appreciation for the finer details of contracting.
Alrighty. Principle, an accepted or professed rule of action or conduct. Now that's very important, because you will learn that contract isn't a piece of paper. It isn't a signed agreement. That typically, and most usually, contract is determined through conduct and circumstances.
Are you suggesting that contracts are express or implied?
They're expressed or implied. I am suggesting that exactly. My number 2 definition of principle, a fundamental, primary, or general law or truth from which others are derived. So now you understand why we're going into why we, the 3 of us, put so much focus on the principles and concepts, because in reality, when you fully understand the principles and concepts, the technology is secondary. The minutia is meaningless. Understand the principles and concepts, and you don't need anyone's technology. You don't need anyone's forms. You don't need anyone's contracts. You'll be able to verbally handle yourself and work your way through commerce quite effectively.
One of the major principles in contract is that actions speak louder than words.
Indeed.
If I was a judge sitting in a courtroom and you people had just submitted to me a pile of paper, as a judge, I am a very, very busy individual. Would I spend a lot of time possibly reading your paper? Maybe yes, maybe no. But if you came in front of me and I got a chance to ask you 1, 2, or 3 questions, by time you responded in your actions and words to my 1, 2, or 3 questions, I would know whether or not anything in that paperwork you submitted was something I would have to read. Because if you fail to pass my 3 questions, everything in your paperwork is irrelevant and moot. And so consequently, you have to understand under these concepts and principles that certain things override what it is that you submit in writing. And because of that, didn't Brandon already tell you that the contract is not the words written on the paper?
Hold up.
The contract is what you are doing in your life following what you said on the paper you're going to do. And your actions of what you're doing is the contract. The words are nothing more than establishing the written reference to what you're doing. And if the words are different than your actions supersede the words, and the judge does not have to read your words. He sees by your actions that you either know what you're doing or you do not understand what you're doing. So many patriots make a copy of some guru's paperwork and submit it into the proceedings. And then you go before the judge or the administrator, and he asks one or two questions, rules against you, and you blame the judge for not following your paperwork. But if you did not pass his oral exam, you're the one that didn't honor the paperwork, and your actions disqualify you from the remedy, even if the paperwork is right and attempts to supersede what you did in open court. Your actions speak louder than words. What Brandon is showing you are there fundamental concepts and principles under contract law that our friend Gordon teaches you that will undo what you intend to do if you don't understand these fundamental principles and concepts.
Are you suggesting if I came into court and filed a lot of paperwork, Jack, and I came in with an attorney because I filed stuff about my sovereignty and UCCs and all of that, the judge might take a look at the fact that I have an attorney and anything I put in is meaningless?
If you have accepted the attorney to represent your position.
Well, I'm not going to accept him, Jack. He's just going to be standing over here in case I need him.
If the court has made the offer to you that the attorney is standby or the attorney represents you.
What if he's just my technical counsel, Jack?
If he's even just your technical counsel. If you do not set forth before the court.
Are you suggesting if I'm just in position to receive a service,
if you
I'm
are
in trouble?
If you're in position to receive a benefit, then you're on the public side. You're not on the private side. The principles of receiving a public benefit means that the court views you as having made a general appearance to the public side, which means you're the public surety, and now all your private settlement documents are moot, because you cannot be a surety both on the public and a surety on the private at the same time.
You just saying I can't accept a benefit? That's it?
You can accept a benefit, but it puts you on the public side.
I'm going to be obligated?
You're going to be obligated. It moots your private set-off.
So my actions are going to speak louder than my words?
Absolutely.
Are you telling me what I say doesn't mean anything just because he's standing there and I entered the bar, or I did something else just like that?
And you contractually did not qualify what rights you were trying to protect and the position that you wanted the court to take with regard to you.
Are you suggesting that motive is determined objectively? My actions speak louder than my words, like you said earlier?
Absolutely.
You guys,
Brandon, what do you think of that?
You guys are in for a treat, because I can't even make it through the intro and you're getting all this information.
Just giving examples.
Like I said, we're going to try to pack a lot in, and they're packing it in there. Good thing I have these two. Okay, concept, an idea, or something formed mentally, combining all its characteristics or particulars, a construct. So, these are just the definitions. The principles and concepts are what you're going to take away from here that are going to be valuable and are what are going to really get you your remedies and be the tools for which you can use to affect change. Now, understand, the most important contracts in your life are your personal relationships. They're the most important contracts you have. When you learn to honor those in everything you do, honoring contracts in public commerce become very easy.
Is anything
very
not
easy.
personal? My relationship with God, my relationship with my friends, my relationship as it relates to the government.
They're all personal, but the
So they're
most
all
difficult contracts to deal with will be the contracts with your significant others, the contracts with your children, the contracts with your parents, the contracts with the people who are closest to you, because those are the people you're most likely to dishonor because you automatically react. Okay?
Are you suggesting I'm just used to arguing all the time,
Yes.
making excuses?
I'm suggesting that. Now, I added this, commerce, because here we've given our endeavor the title Creditors in Commerce. Now, I want to give you an idea of what commerce is so that you realize it's not just things that have to do with money.
Is it also the buying, selling, and trading of commodities?
Yes. And social relations. The exchange of views and attitudes.
Is that not a commodity?
Sexual intercourse. And I don't think it means with the exchange of money.
It's not. I heard that commodities is anything of value or use.
That could be.
So an idea, a concept, all this means kind of what you said?
Yeah, those are all commodities.
Okay.
And intellectual or spiritual interchange, communion. I couldn't believe when I actually read this in the dictionary. I'm like, what? Really? I'm all, wow. What insight I must have had in choosing the name. Because it really covers everything. So, commerce covers everything. Alrighty. Here we go. Who am I?
Well, what's who mean?
What?
What's it defined as?
Who is defined as
What or which person
what
or person?
Which. Yep.
A what or a which person or persons?
Yep, that's how it's defined.
Wow. So who am I is kind of important, huh?
Well, what's the definition of I?
And what is?
What is. Okay, so you heard Jack go on a little bit about you're not the name, you're not the title, you're not the body. In fact, any distinction you can make, you're not that.
Some of you might find me, I'm a little pedantic when it gets into the dictionary because I can understand something like a name. What is your name is one thing, but a name is a word by which a person or thing is known. So it's easy for me to understand I'm not a word, Gordon is a word, so therefore, literally speaking, I'm not Gordon. And then I tie it back to I'm that spirit in the body, that connective electrical impulses that animates this frame. And that helps me.
You know, in Scripture it says, before you were born or before you existed, I knew you. At that stage, you didn't even have a name. So who am I really has nothing to do with that name. When Alice in Wonderland was asked that name, if the depository trust company calls you up and says, who are you? You better be able to understand what they're looking for. And when the court says, who are you, or what is your name, as we suggested earlier, when it comes to commerce, how do they tie down the responsibilities and the duties in commerce? Don't they attach those to a name? So if you're in a courtroom and the judge says, are you Jack Smith? Or if you're there and you won't give a name and he says, who are you? The name is the person. Is that a real entity or a fiction? It's a fiction. The name attaches to some object, and they want you to attach to that object, so they have someone to be liable or a surety for that object. So who am I? The real issue that they're getting at is, are you on the side of the object which is liable Or are you on the side of the object, which is surety to set off the liability?
So they just really want to know my status when I'm in there?
That's true. It's a status question. But do we need a name if there is no debt? Because the name attaches to an object for which there's got to be some problem associated with a debt, and they're just trying to settle the debt. Otherwise, the name is not important. Remember in Scripture that God was having this conversation with Moses, and he was speaking from the burning bush, and he wanted Moses to do something. He wanted Moses to go back to Egypt and negotiate a certain commercial settlement and closure with the Pharaoh. What was the account that God was trying to set off? The debt of Israel, which is why they were in a slave condition to the Pharaoh. And the account was now timed up. The account was there to be set off, settled, and closed. And God appointed Moses as his authorized representative to go back and settle this commercial account with Pharaoh. Now Moses kept saying, well, who should I say has authorized me to set off this account?
Was Moses trying to get rid of his liability there?
Well, not Moses. Moses was suggesting that when he showed up, if he's going to be the authorized representative, somebody's going to ask you the question, who authorized you and who are you representing? And in terms of the things of this world, when it deals with a commercial liability, who am I? Your first response is, my name is. Because the name is associated with the commercial account.
So he didn't ask me my name, did he?
No.
He asked me who I was.
But see, if Gordon and I are going to have a nice time, do we go out and we transact a nice time? Do I need to have his name to do that? Or because I exist and because Gordon exists, if it's a non-commercial world, can we just relate to each other without even giving a name and go out and have fun? Now, if you give the name, by giving the name, you have surrendered something. You have surrendered some authority. And so God says, wait a minute, I'm not in commerce. I'm the ultimate surety here. You're not going to get my name from me.
Kind of interesting is to look at the definition Webster's on book, as though you were being booked into a police station. Why do they need your name? To register a name, to enroll, to create or open a pecuniary account where damages can be lodged.
So by the giving of the name, you have just given up the commercial energy. God said, just tell these people, I am that I am sent me. Are the people on the other side going to go, well, gee, we didn't get a name, so we're not authorized? Are we going to go into a dispute over the authority that the authorized representative has obtained from another, which is none of our business? And so this whole question of who am I deals back to the subject matter of them drawing you in to be liable on the public side to settle this account. And as we're going to see this weekend, there is no ability or remedy on the public side to settle any accounts because there is no energy there which they recognize to zero the claim. You've got to come from outside their public jurisdiction to set off the account. And you're going to send an authorized representative there. So at the heart of who am I? They're just asking you, do you know what relationship you are bringing to these proceedings? Are you bringing the relationship of the debtor to which you're publicly responsible, or are you bringing the relationship of an outside creditor, and that is who you are appearing in their game as? But as a living soul, you exist, and only God knows you. You do not have the name that they want you to give them in the public. In the movie Dune, remember the young prince who went to the planet and that was mining all of the spice. When he finally learned who he was by listening to the natural population of that planet that was not registered to the empire, when he learned who he was, did those people not tell him that it is the custom to take on a new name as symbolic of who you have become when you moved from registered under the empire to the living knowledge of who you really are in terms of your commercial energy to resolve problems? And he took on a new name because he had a new relationship to commerce. The new name was not registered to the public, and we'll talk about that later on, what that registration does and how we get out of that. But this whole question relates back to the substance of your remedy. And if you do not understand how critical this question is and how you respond, you will not understand any of the remedies that you've got to settle your commercial problems.
And a little of a esoterical kind of standpoint, my own spiritual come from. I am that I am. He didn't say I was what I was. The name, anything that you're basing on the past, an event that is not in the now, is fictional. The name was given at a point in the past. It is not in the now. It has nothing to do with who you are. When we learn to let go of the attachments of everything of the past and come from a new moment in the now, you will learn unlimited power, because there is nothing holding you back. Everything of your past holds you back. It is where debt comes from. It is where sin comes from. When you are able to forgive and detach and let go, you have infinite power in the now. Like I said, it's esoteric, so a lot of this may go for a lot of people. It's how I came to my understanding. Oh, how about that? Past equals dead fiction, jurisdiction of fictions. So, I just kind of touched on that. Everything in the public commercial world is based on events in the past. Charters for corporations, including the Corporation of the United States. Registrations of vessels, including the vessel by the name that you think you are on a birth certificate. All these events, all things, we're always bringing back and recreating from the past and bringing it into the now. If everyone in this room were to let go of everything from the past, we would be in a true moment. We would be experiencing truth. We would have no attachments. We would have nothing holding us back from where we're going. There's unlimited possibilities when you're not attached to what was in the past. It's a very powerful concept and principle to live from. Future, also, never happened. When is it the future? Never. You're always in the now. The future never comes. When you base your actions, conduct, beliefs, ideas on something that hasn't happened, especially if your conduct is determined by your fear of something that's never happened, that's another way of restricting what's possible for you. You have nowhere to go if you're coming from fear of what might be. You limit yourself. You limit your possibilities. Now, what I call living truth and jurisdiction of the living. See, I broke this down as jurisdictions. I call them jurisdictions. Past and future jurisdictions are fictional. The only true non-fictional jurisdiction is in the now. The only reality is the now. Remember what we said about truth. You may recall something from the past, your experience, your story, or his story, right? And you superimpose your story over his story, and your experience of your story and his story, you make up to be something, and it guides you through your life. It restricts you, it limits you. But it's an experience that has no fact. It has no truth. It is what you made up. It is what somebody else made up. It's taking what you make up and what somebody else makes up, superimposing them. That's fiction. So the jurisdiction of fictions is in the past and in the future. Again, you will learn unlimited power in the now. And I will even give you examples of an experience I had where, coming from the now and unlimited possibilities, I determined the outcome of a situation. I created from unlimited possibilities something that would seem impossible. Oh. Can you defend? Why do I defend? This is another thing that, again, the best place to practice this is in your personal relationships. A couple weeks ago, my ex-wife, she loves when I talk about her at these seminars, by the way. She told me. She calls me on the phone.
She's still listening to you, right?
Yeah.
That's positive.
So she calls me on the phone, and immediately we get into a thing. I got to be careful about how I word this. But what she was saying seemed to be an attack on me. Okay? Now, coming from unlimited possibilities, I wasn't going to defend myself. I didn't take it personal. I let her say what she had to say. I did not make her wrong about it. I did not have a need to be right about something else. I did not make up that what she was saying had any validity to it, but I was listening in such a way that it led me to ask questions of her. And we went from a very heated conversation to a very productive conversation where we were both very civil. I completely transformed what could have been a fight or an argument by not defending, not even needing to defend myself about what she was saying about me. Just listening very intently, asking questions, not making her wrong, not needing to be right. See, this is a very important concept because when you get challenged, when there is a practical exam of your position, and you go into defense, all of a sudden you're going to start rolling downhill on your process. When you think you need to defend, when you need to be right about something, things will start blowing up in your face. Don't need to be right. Don't need to make someone else wrong. Let them have their position. Conditionally accept it. And return it with your own conditions. You can control any contract. Remember, all relationships are contract. It wasn't that I exerted control over her on the phone. I didn't need to. Because I didn't need to defend. I didn't need to make her wrong. I didn't need to be right. And yet, I completely transformed the transaction, the exchange, to something very positive. And based on my past, that's not how I used to do things. Typically, if she would have called me and started accusing or assuming or saying something, I would automatically start defending myself. I would automatically start making her wrong for her position. I would need to be right about how I saw things. And it just escalated. And now, through my practice of these concepts and these principles, I'm able to take someone who calls me with very heated, passionate, very angry, and completely transform the exchange. And you can do this when you can do this in your personal relationships. In commercial relationships, it becomes very easy to completely transform something by not needing to defend a position.
It's probably going to become a little even more important not to defend, because you understand that you either serve God or you serve man. And if you serve God, He tells you, agree with your adversary quickly. That's the rules. Just accept that. And under the 4 doors that we've talked to many of you on, that any acceptance or any offer that you receive, you have only 4 doors that you can go through. And we know that door 4 is arguing, and arguing is comprised of making statements, justifying, explaining, etc. You lose. You're a debtor, you lose. You cannot win an argument. No point in defending. No point in violating God's law. He told you, do what He tells you to do. He'll give you everything. If you wish to serve man, then you know what you're going to get. A lot of confusion, a lot of problems, and you're not likely to get the remedy you want. Whenever you're up against government, police, other public officials, they're there to help you. And if you're going to defend or you're going to argue or you're going to go into their world, don't look to win. Don't look to settle the matter. Don't look to be what a creditor has coming, remedy, which is to help his brother. If you argue with your spouse, and this is why Brandon is telling you, the spousal relationship is where it's going on all the time. You get to deal with that interaction all of the time, every day. Try it with the spouse. Try just agreeing all the time via questions. Nobody said you had to argue. If you do, you're undermanned, you're in door 4, you're a debtor, do not expect remedy. If you'll conduct yourself as Father in heaven would have you do, as a creditor would do, then remedy is going to come under any circumstance. Agree with the other person. Always. The police officer stops you doing 82 miles an hour. And the wife says, yeah, this. And she's going to run out of gas. He's going to run out of gas. That other person's going to run out of gas. The law or the contract will be on your side. You're creating the contract. You are sovereign. But what's sovereign? Authority. That's all it is. You're merely the authority for all of this. Law equals contract. Consent makes the law. Have at it.
Understand, when you're talking about defend, you're already dealing with some commercial transaction because somebody's accused you or charged you or wants you to be responsible for something. The first thing you've got to ask yourself in any contract after we know who the parties are is, what jurisdictional venue is this argument taking place? Is it taking place in the Republic, which is the real world, or is it taking place between the characters with the names? Is it in the democracy? Is it in the world of fiction? And so the issue is, if you argue or defend yourself in their jurisdictional world, you have no remedy because you're a debtor by arguing. Is there an argument going on in the real world for which you have to defend yourself? This morning, Gordon and I were sitting there at breakfast. Somebody brought us up an interesting communication. It dealt with trying to settle a tax issue. This particular party had done an acceptance for value, a return for value, and authorized a set-off from the asset side of their account, which is in the Republic, and they tendered that offer to the head of that particular taxing entity, the commissioner or whatever, and it was tendered on the private side. There was no argument so far. They said, would you like to settle an account? And the other party came back as the authorized representative of the creditor side of that account and went to the private commissioner and said, there is no defense. There is no argument. I authorize you to go to this account and just transfer the units which don't exist except in the minds of everybody by the numbers assigned to that account.
Credit money, data entry.
What happened is the commissioner never wrote back and said, I don't like what you're doing. I don't think you can do this. Instead, a third party, someone that worked on the public side of the revenue department, wrote back and in the first part of their letter said, you can't do this. There's no such account. You're listening to all this patriot crap. And if you continue that, this is illegal. This is bad. You're going to get in all kinds of trouble. Then down at the bottom of the letter, it said, but if you would like to basically come back and talk to somebody to offer a settlement, contact this party. The first part of this letter was an argument defending the public perception of these actions down in the democracy. Isn't the democracy the world of illusion? If you argue with someone that's insane in a world of illusion and you're defending yourself in that world, haven't you just done a general appearance to the world of the illusion? How can you then be the authorized representative having made an offer to settle a claim to the commissioner? Now, the commissioner can sit on the private or the public side of that account, just as each of us can choose to be the authorized representative on the private side of our account, or we can choose to play the role of the defendant and defend the charges that are down here in the public world. But to defend in the public world charges in a world of insanity makes you insane and makes you the debtor.
Give it a thought. Give it a thought. If you're going to consider making statements, making arguments, explaining anything, and it's really hard to give it that thought, you are going through door 4. You are entering the world of the insane, and only insane people would think they could get anything out of an insane world but insanity. You got to be a nut to do that. And it's hard to imagine that. So every time you get ready, they didn't do it right or something, I'm telling you, just like in this letter this person got, the remedy is right in there. Whoever argues is insane, and that insane, then they're part of that world. And you as the sovereign can always get remedy if you adhere to the rules. Don't defend, don't argue, don't make statements. Settle the matter.
Here is the part of that letter that these people that came to our table didn't quite get, because it's what is not there which is more important to what is there. Who did you tender the settlement offer to?
Tendered it to Commissioner
The commissioner on
over
the
here.
private side.
And I came in and said something to him about it. He didn't.
Did the commissioner write back to you and tell you you couldn't do it? Okay, so did the commissioner on the public or on the private side defend the position that this third party is trying to bring you into? No. So if the commissioner on the private side did not defend any claim against what you did the commissioner on the private side agree with you? Yes. With that agreement, neither party is defending anything. If you come back in response to this third-party letter and defend your actions to this third party, you don't have to defend your actions in the private, because you do not have anyone opposing you. Do you all remember the story by Cervantes, Don Quixote? Wasn't that story about a well-intentioned want-to-be knight to defend the weak, to defend the downtrodden and the debtors? And he always went out to fight a battle against an enemy that was never there. He was tilting at windmills. It wasn't there. Don Quixote didn't have to fight for anyone. When he did, he was fighting the public, which are lunatics. The point I'm making is, in the private side, you don't charge your brother because your brother won't charge you. If you don't charge your brother, does he have to defend himself? No. If he doesn't charge you, do you have to defend yourself on the private side? The answer is no. These people are trying to hook you and pull you in to the world of illusion, because when you defend yourself against an illusion, you are not real in the moment. If you're not real in the moment, we don't know who you are. And it goes right back to losing again. If you don't know who you are, if you are playing a role in the public under this illusion, you cannot be a creditor in private and set off and settle these cases. So you do not have to defend in the private. Everybody in the private is honorable and doesn't charge your brother. The commissioner never came back and accused your acts and actions of setting off this account as being wrong. He got an imposter to come back and try to solicit you back into the public, where if you defend your claims in the public, you've just moved from the reality of your agreement with the commissioner in private, and you've now come back and lost your suretyship in the private. You're now subject to all the liability that's in the public.
Focus on the reality of it. You sent in your acceptance for value to the commissioner or to whomever, the bank, the court, your brother that sent you a bill. We talked about the Aunt Marge defense, wherein we have a couple of students that are on federal indictments over an IRS matter. They tendered an instrument for set-off on the matter, and they ended up being indicted over it all a couple of years later, et cetera, et cetera. But this particular gentleman was explaining to his 83-year-old Aunt Marge, and many of you have heard this story, that he had given this esoteric financial instrument, etc. And Aunt Marge just said, well, did they keep it? And he goes, yes. And she goes, they've been paid. So under the Aunt Marge defense,
knows.
it's critical you remember that when they kept something under contract law, they're in agreement with you. They've been paid. This person submitted an A for V, R for V to settle and close that particular account, or settle and close the account, or just simply settle the account. And in so doing, did that person, commissioner, bank, CFO, other party, keep what you sent? Have faith. If they kept it, there is acceptance. And the most important and critical part about acceptance is it creates a binding contract. Not a contract, a binding contract. Therefore, focus that when they kept your A for V, R for V, settlement proposal, that person on the private side has it and has kept it. Therefore, that is, anything else that comes in is merely a test to see if you understand what happened. And of course, we know that if they send it back, that's a beautiful thing too. Because then there's going to be discharge to the amount that was tendered, etc., pursuant to UCC 3603. Brandon?
All righty. So, I think we've hit on actually proof and belief. Proof is based on belief, and belief is based on your experience and your own faith and confidence, and you cannot compel faith and confidence in anyone else, so you can't prove anything, and your belief is your belief. Now, Gordon just started in on offers and acceptances and how it creates a binding contract. When the offer is coming at you, there's two ways you can handle,
4 ways to deal with it.
well, there's 4 ways to deal with it, but two
Classes.
subjects, classifications of reply or non-reply. And it is being in honor or being in dishonor. And see, being in dishonor is a disempowering place. It's where you give away your power. You lose control of any contract when you're in dishonor. And again, not only in the world of public commerce and financial transactions, but in your personal relationships. Now, being in honor, there's 2 ways to go. You can be in full acceptance of an offer. You know? So if somebody asks you for something, give me that cup, stand up. You can be in full acceptance, give them the cup and stand up. Or, if you want to be in honor, you can conditionally accept their offer, which is a counter offer. And a counter offer has
the legal effect of rejecting the offer, more technically defined by blacks, a statement by the offeree which has the legal effect of rejecting the offer and making a new offer to the offerer.
so
That gives them the honor and the power of acceptance. It's all about honor.
And so now you've taken control of the contract and put the conditions. So, give me that cup. I'll give you the cup if you give me $1. Right? So now you're in honor with their contract, but you've changed the conditions of the contract.
Well, Brandon was just had a thrill here this last weekend or two, and they asked him for his name.
Hold on.
What was your counteroffer?
Hold on. We're going to get into that when we get into sovereignty and authority.
All right.
Okay. I don't want to go into. We only got a couple minutes before the break, and it's a long story. So the way I see it, when I decided to call what my endeavors were creditors in commerce, I did not look at the word creditor as what people typically think creditor to mean, which is someone who is owed money, someone who lends money. if you're open, let's look at creditor, being a creditor, as a spiritual endeavor, to being in honor, to creating solutions in not only our personal relationships, but in our communities, in our government, in our world. The creditor will be the one who's giving and putting the energy out there to solve everyone's problems. That's when I use the word creditor, and I believe my friends up here probably use it in the same sort of context. It's not, I'm a creditor so you owe me money. No. I'm a creditor because it is my spiritual endeavor to solve people's problems, to solve everything and everyone's problems. That's what we mean by creditor. So I wanted to make that distinction. Anything on that? We're about to 2 minutes.
Well, it's interesting with just creditor and defining creditor. One to whom a debt is owed is one way to look at it. And what Brandon's talking about is another way, and where Jack was talking earlier, referencing surety in the public side and surety in the private side. Try and open your mind so that you don't get too confused about when it's used in a certain context. Because I tell people, when you're defining a word like running, if we're talking athletics, then it's easy to define running as, much faster than a walk, etc. But it doesn't have any relationship when I'm talking about running for office, or if I'm a painter and the paint is running down the wall, or I'm in the medical industry and I'm talking about the nose is running, or my nose is running. Context is going to be everything. So you have to listen carefully to Jack's and Brandon's context that they're giving you that word, and don't get little. Well, I thought they said it meant this over here before. This is confusing. Relax. Open your mind. Some of this will sound a little confusing to many of you, and especially if Jack talks. And because me and Brandon are confused, so we can imagine what's going on with you. But in the reality, open your mind to what Jack is saying. He's telling it to you in a way you can hear it. Brandon says in a way that is heard. I say it in another way that it's heard. But it's really all the same thing, and it's the same things we've been saying, and at this point in time, anticipate to continue to say.
If we're running out of time, maybe after the break, we'll qualify a little bit about offers and counter offers and what you do at what time, because it's very critical in that if you're looking at a commercial account with some kind of public entity, like a court or a bank or something, they've already presumably got a debt account set up for the scarecrow or the straw man, and they're tendering that to you in some manner. Generally, the first round, you want to do a full acceptance, because if you condition anything, you've kind of rejected that offer, and what you want to be totally in control, just do a full acceptance on the account to zero it. Now, what's going to happen is on their initial offer, it's kind of like contract, subcontract versus employee and employer. They say, this is what we need, X number of units, dollars. They don't tell you how to do it. So you're free as a subcontractor to set off the X number of units or dollars either by the asset side or by the liability side. They're kind of assuming you don't know anything about reality. So they're assuming that you're going to come back on the liability side like everybody else. But that would be what an employee would have to do to an employer. You would have to do it the way your employer asks you to do something.
Let me
If you're independent, just a second,
Right.
if you're independent as a subcontractor, you got the liberty and freedom to perform the task, to give them the end result, which is X number of units. So if you're doing a full acceptance and you're on the private side, you're going to do the set off with what we've been referring to as the asset units, and you've achieved what they've asked you to do. they're going to be the one that's going to come back with the counter offer to try to drag you back to do the set-off in the public side. And what they're saying is, would you all please come in and be our employee so that if you don't do it the way we ask you to do it, we can punish you and sanction you. In which case, when they give you the counteroffer, you got to come back with the counteroffer to their counteroffer to drag them back and allow you to do the full settlement on the private side, which you have a right to do. So what they're trying to do is get control over you by getting you to agree with their counteroffer to your full acceptance, that you'll just come back and do it the public way so that we can control you and tell you that your asset funding is no good. But if you don't give them a full acceptance to the first offer when they have not qualified to you what way you are compelled to perform, then right away you're already in problems because you're not fully accepting the responsibility as a surety on this account on the private side, and now you're in dishonor because you haven't settled the agreement. So it's usually always a full acceptance to an established account, and then after that it's going to be a counter offer when they come back and try to drag you away from the conditions of your full acceptance.
You know, one of the important things Jack mentioned earlier was how you pay it. And it's interesting, one of my students recently, when she was assessed a court amount of $5,000, she went down to the clerk's office and asked the clerk, "How do you want me to pay this?" And the court clerk in Colorado said, "Any negotiable instrument." You simply need to understand what a negotiable instrument is. You're the one that creates that negotiable instrument. So Jack's telling you, they didn't tell you how to pay it because they can't. They can't say pay it in U.S. dollars, Canadian dollars, pesos, or anything else, or gold and silver. That violates public policy. So if you're out of money, borrow Jack's pen or Brandon's pen. I'll get you one. We got money, folks. Have a nice break.
Okay, creditor ontology. Ontology is a word, basically means the study and endeavors of ways of being. Okay, again, this is probably, at least for me, the most important aspect of being a creditor is those ways of being. Okay, so we're going to do like a little comparison of creditor versus debtor, and some of the traits that we want to consider. And as we go through the list, become aware and conscious of where in your life, on a personal level, professional level, whether it's with your employees, your boss, in your workplace, or in your family life, where you're being a creditor and where, and most likely, you're being a debtor. Okay? So, creditors ask questions. Debtors make statements.
Yeah, but can't I just explain something, to get a point across? And is that going to make me a debtor if I'm just trying to explain something, or I tell somebody something? Can't I just,
if you say something and you're explaining something, then are you not taking a position on something?
I guess that makes me a debtor. So you're telling me I can't make these statements or can't explain
something? You can
make
them.
Huh? I can make them, but I just got to suffer the consequences of being a debtor.
Right.
Well, I guess I better not be making any statements or any of that stuff then, huh?
Is it making the statements defending a position?
It is indeed.
And what did we just talk about defending?
Yeah, but.
Shut up.
Creditors Take responsibility. Now,
Yeah, but it's not my fault. They brought the charge. I didn't bring it.
Right.
He stopped me on the highway. I wasn't doing anything.
Absolutely.
Oh, you mean I'm making a statement? Damn.
Yeah. So, taking responsibility, this is actually a much deeper, it takes you need to take a very earnest, hard, comprehensive look at what truly taking responsibility is. It's about being the author of your experience. I am absolutely the creator of my experience, the author. I am responsible for what I experience of my community, what I experience of my government, what I experience of my family, what I experience of my friends. I make it all up. Debtors, blame and complain. Anyone in here ever blamed or complained? No? No one? Oh, wow, amazing. We got a bunch of creditors.
You know, when you're thinking about being a creditor and you want to take responsibility, just picture that you got this huge, big, vast pit full of all the money you want to grab. You can afford to take the responsibility. And until you can get that in your mind that, in fact, your exemption number, that you have the authority to discharge debts, everything from tickets to you name it, it's going to be very difficult for you to want to take on the responsibility, all of these things. So you're going to need to get into the very depth of what this is about, who you are, and how you can operate on it. We were joking earlier in a sense, if you don't have money here, use my pen or Jack's pen. We're not joking. That is absolutely it. You can afford to take the responsibility. So somehow you've got to arrive at understanding you truly are the creditor, and you can provide the credit to discharge the debts that are making your lives so miserable. And that all of this other stuff, just like Brandon recently took on a situation for everybody. He acted the creditor. A little problem there. He took it on. You'll hear about it later.
Understand that our currency is the energy that we possess as living beings. That's what backs the currency. And you are the living being with the energy, so it's your currency. Does the government exist as a living being? No. So the government has no currency that it can put into existence because there's no energy to back up that currency. Now, what demonstrates that you are authorizing the creation of currency based on the potential of your energy to create something to back that energy or that currency is really the fact that you exist. And to exist, you have to move. When your hand moves, it represents that you exist. So your signature or no nature is what happens when your hand is moving to prove that you are living and you're creating a currency based upon your no nature or your signature. That's what creates your currency. It used to be under the Constitution that lawful currency was based upon the existence of lawful gold or silver coin. That's gone. It doesn't exist in the living real world because under the Constitution, the national government Congress was able to define what that real currency was. And in 1933, they undefined a definition. So there is no definition of real currency as it exists in behalf of the several states. The national government nor the state governments do not have any commercial energy because they're not living. So consequently, what everyone is using as a currency today is the contract which says, I will produce some commercial energy and deliver it to you. And the way that we represent that contract in the commercial world is through your no nature and the fact that you demonstrate you're alive. If you couldn't move your hand, you would straight line, and in the medical profession, you would be called dead. And you can create no currency.
All righty. A creditor is neutral, takes no positions. Debtors are biased and take positions.
Let me comment upon that. During the break, a party came up and said, I did an A for V, R for V, and I tried to settle a state issue. And the state kept coming back saying, what you have done is nothing. We do not agree. A judge, many judges came out and said, we're overruling you. You haven't settled and closed this at all. So I said to the party, what did you do? And the party said, I went and I filed a motion to disqualify the judge based on bias. Let me ask you a question. What makes a debtor? Aren't you arguing and defending? Now, if you're in a public court case, who are the only entities in a public court case that can file a motion? A party to the case or an attorney. The party to the case is your straw man defendant, right? Who owns the straw man defendant?
Government.
They do, because the birth certificate assigned ownership to them. So they own both parties in the court case. They own the plaintiff. They own the defendant. If you file a motion in the case, who have you just acknowledged yourself to be? Either the plaintiff or the defendant. Or you are an attorney. But we're not an attorney licensed by government. Who else could possibly appear in a case other than the parties or an attorney? Some outside party that might have some standing in the matter.
Could be a real party in interest, you're saying?
Real party in interest. But then the oxymoron is if you file and register in that case to be allowed to appear, and they authorize it, you are now appearing in public. And you can't bring a private remedy. So the only way you have standing in the case is to be an outside party that doesn't formally register to appear. You're there privately, but not registered publicly. If you're not registered publicly in the case, can you file public pleadings in the case? No, because you're not authorized. So if you're appearing privately in this matter, representing a real party of interest from outside the public jurisdiction, how do you have to appear in the case when you communicate? By private correspondence.
Are you saying I'm still going to be able to put some stuff into the court then, Jack?
Absolutely.
But it's just not going to be on the public side.
Right, so you can't have it filed.
It might be received?
You can tender it and have it marked received.
So it might appear just the same as a regular filing, but it's just going to be stamped differently is what you're saying.
Well, it won't appear in the public file of the clerk. It will be on the private side of the file, which the judge can see in chambers.
So I shouldn't really worry about it when I file something if I'm doing it correctly in the capacities that are outlined. If I put it in there, They'll take care of it probably, is what you're saying.
If you're doing it correctly and you're not misrepresenting it, if the clerk says, would you like to have us file this? Ma'am, is this not tendered on the private side? Is not my directions that it be sent to the judge as a private manner? Ma'am, would you be so kind as to stamp my copy received, stamp the court's copy received, and direct this as a private communication to the judge? Now,
Well, what if she tells me she's not going to do it, Jack?
well, then I would suggest I conditionally accept it on proof of claim that the judge has given you authority to intercept his private communications with another party or another entity in this action, because you're coming privately, on condition that you're going to accept responsibility and liability for the prejudice and damage you cause the real party of interest that I'm representing by authorized representative. You think the clerk's going to take on that liability?
Are you suggesting the clerk might just act as a bureaucrat and do her job without making any intelligent judgment?
Maybe, but you see, I'm not
I think that is what it is, isn't it?
I'm not sending just one copy through that clerk. I'm sending a copy of this private process to the prosecutor or the plaintiff or the plaintiff's attorney, and so there's 2 or 3 copies of this private correspondence. And if I have shown in my correspondence that I've served a copy on the clerk to be conveyed to the judge, and everybody else on the private side understands what I did, and the judge is going, well, where the hell is my copy? Well, Your Honor, I tendered it to the clerk. Maybe the clerk interceded and interrupted your document. Go see your clerk.
I've actually sent it in directly to the judge under registered mail on multiple occasions, and the judge has taken notice of that which was received on the private side.
Yes, and then what the judge will do is the judge will say...
How did he take notice?
He actually...
when you went to court, or did you get something back, or what?
I never even had to show up to court. I simply put it in under a letter rogatory saying, Your Honor, I wanted you to be aware that here's the record of the private agreement between the parties.
So are you telling me that you created administrative remedy first, and then you sent that to him?
Then I sent it to him on the private side, letting him know that there was settlement and agreement. And this court case went on for over a year. I never showed up in court once, and then all of a sudden one day it was shut down.
So you're saying if I went in and maybe did my private administrative remedy in these matters, and then I sent it over to the judge within a letter rogatory or appointment of fiduciary, that he might actually do what he was appointed to do?
Yes.
Because they always do it right?
Always. In fact, there was another court case I was working on, and the judge, every time, I wasn't putting a call to action in on the court, but I kept answering, and I kept answering in such a way that was conditionally accepted.
Hold on. I don't understand what you mean, a call to action. You lost me a little there.
I would always respond in a way that I took away the effect of the opposing party's filing. However, I wasn't putting in something to move the court to do anything. So the judge would actually take up my position, and he would say, okay, basically he would recognize that I've taken away the plaintiff's claim. There is no claim. And so he would put in an order for the plaintiff to show cause why the matter shouldn't be dismissed. He did it on multiple occasions. He did it on 3 occasions. Every time he'd go, okay, he's taken away your claim. I'm now putting in an order for you to show cause why it shouldn't be dismissed. And each time they would file something new. And I would wait like 3 days before the hearing, and I'd file something on top of it. Wait 3 days before the hearing, file something on top of it. And each time I go in there, they don't have a claim because I filed whatever I had. Last thing in is the first thing out in the court. So the judge would take notice of my thing, notice that it had taken away any power of their thing. Then after the hearing, he would put in an order for them to show cause why it shouldn't be dismissed.
So you're kind of saying if I did my administrative remedy, put it in, and I might come into court.
I should have been moving the court. I should have been walking in saying, here it is. They have no claim. I'm putting in a proposed order. I want the plaintiff to show cause why this matter should not be dismissed, and I could have had it in that hearing rather than giving them an opportunity to file something again on top.
Well, for example, like I file something and they answer and I answer back and say, upon proof of claim that the record of set-off settlement and closure not by the authorized representative hasn't made that matter moot, I've stopped them from what they're doing, but I haven't called them to action yet. So in that kind of a case where my private record's now on the top, Are you suggesting my lack of inaction causes me problem? All I really needed to do was what? What do you mean by call to action? I mean, I've stopped by...
The court does not move itself.
Oh, okay, so I've got to move the court.
If you don't move the court to do something...
What might I say to do that, Brandon? I'm a little unclear.
Well, let's see. If I conditionally...
I just say I can... there was a case where this guy Hall was down in San Diego, and he's in front of the judge and said... Judge said, well, I'm going to appoint an attorney to you, Mr. Hall, before you hurt yourself. And I said, I conditionally accept. Now, remember, at that time, this guy Hall had his administrative remedy in to settle the matter, but he was in being tested. And so the judge said, I suggest you get an attorney before you hurt yourself. And this guy Hall, he says, are you suggesting I can't resolve the matter directly without an attorney receiving public benefits? And the judge looked at me, at Hall, and he says, no. And I just was, so what you're saying...
You just sat there. Basically saying,
I'm not going to say I
saying
sat
that
there
at
like
all.
a bump on a log. I looked stupid, but I wasn't a total bump. So I should have called him to action, Brandon, by simply saying, when I said, are you suggesting I can't resolve this matter directly? I should have said something about my private record that had already settled this matter.
Yep.
And therefore, I might have done that how, Brandon? I said that. What would I have said?
But if you're...
Or Jack?
You've put in that the record had settled.
Yeah, the record was in.
Okay.
I settled the matter.
And if they go silent...
Well, they agreed to all of that.
Okay, so now they're in agreement. So let the record show that there is no opposition or objection to the fact that this matter has been settled on the private side. I am now going to move the court either with an order to show cause, why it shouldn't be dismissed. If they cannot show or provide proof of claim or state a claim upon which relief can be granted, then I motion this court to dismiss this case with prejudice. See, I'm moving the court to do something. I'm saying, we've got this agreement, we've established that there's this agreement, and now, because there's this agreement, this is what I want you to do. If we just say, we've got an agreement, there's a private agreement, and then we sit back and wait for them to figure out what to do with our private agreement, nothing's going to happen.
You haven't asked the court.
Exactly.
If you don't ask, it shall not be given to you. But there were two things that you said. You asked the court to dismiss. Don't ask the court to dismiss. You ask the court to discharge, because remember, you've come in as the surety to pay the account. And what you want in the military is if you're in there and you want to get out of your responsibility of the military, you don't ask them to dismiss you. You'll have to come back tomorrow. Okay? But if you ask them to discharge you, then the documents go in and the accounting is complete and you don't have to show up again. So you're requesting a discharge of the accounting in the case as the defendant has been made liable, and you ask them to discharge and close the case, which is different from a dismissal. Everybody understand?
Yes.
At all prisons, county jails, etc., you have an R&D, receiving, and it's not dismissal, it's discharge. That's where they receive people, and sometimes they discharge people, but they mostly release people. They put them on supervised release, probation, etc. They've been leased.
They receive collateral to cover the debt. When the debt is finished, they discharge the collateral. It's purely commercial.
Purely.
It's the receiving department and the accounts payable department which discharges the claim. That's all they're doing.
Let me give you an example of, there was a young lady that we recently got out of jail. She'd gone, we'd put in, she'd been stuck there for 27 months on an indeterminate sentence. She wasn't getting out. And they wanted her to provide certain things that was impossible for her to provide. So every quarter, she was called into court. She says, how can I provide the records that don't exist anymore? This is not my problem. Back in she goes. 27 months. We stepped into the case. 5 weeks later, she was out. But one of the most important things to understand is when it came finally down to it and we did our administrative procedures settling the matter on the private side, the final deal was the IRS had put in a statement with the court saying, she hasn't provided this. We're recommending again that she stay in and be stuck there till she produces these things. That was an offer. Now, we'd done all of our stuff, and we simply moved the court with a simple show cause order why she shouldn't be discharged, blah, 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 blah. It was, I think, a 2 or 3 line show cause. Some of you have that, and if not, it's available to you. And she walked free. Because, as Brandon's telling you, many of these where we go in and we stop them from doing something. Or I had a particular associate that didn't do supervised release after getting out of prison. He was called into court in Chicago, and the judge asked him, why aren't you doing supervised release? And he continued, said, where's the contract that obligates me to do it? And he would go back and forth, 7 different hearings. The judge couldn't get him, and he couldn't get out. He'd done a ton of paperwork to settle it, but he wasn't doing what Brandon's telling you and Jack is telling you. You've got to move the court. You are the court. The judge is over here, simply the ref. It's now your court. You've discharged the debt. You're the only person there withstanding to charge or move that court. He didn't do it, but the judge couldn't get him, and the judge finally got tired after 7 hearings and said, Mr. So-and-so, you've wallpapered this court, or you've papered this court from wall to wall. Get out of my courtroom. I don't want to see you here anymore. That's one way to do it, or you simply could have obviated 7 hearings and the aggravation and the gut ache with it by simply understanding your process. After you have your agreement on the private side, your court, you need to move it with a call to action.
Absolutely.
Okay, we have unfinished business from 10 minutes ago. I may be old, but I'm not senile yet, I hope. We were talking about the lady that was in front of the court, and the judge said, we're not accepting what you did. This is no damn good. Now, her remedy was to go back and put in a motion to disqualify the judge. She had to be a party in that case to put in the motion. The motion went in on the public side, so who was the only party in that case that would have had the authority or standing to put in the motion to qualify the judge?
The defendant or the
The defendant. The defendant is the scarecrow with no brain. Why does the scarecrow have no brain? Because he thinks he can solve a problem that is commercially unsolvable in the private or in the public side. And so this party went in and entered a motion into the court to disqualify the judge based upon prejudice. So who did the party just assume the role? What is the subject matter that Brandon is talking about right now? He's talking about the differences between the way a debtor acts and the way a creditor acts. We're trying to bring reality, and we're trying to bring Brandon's discussion on this board to life and show you by examples. Because we said earlier, it's not in your paperwork who you say you are. It's not in the court who you say you are. It's who you're acting as. Your actions speak louder than your words. This lady brought in a set-off and settlement to these tax accounts in the state. She wants the public to acknowledge her set-off and settlement. When she didn't get the proper response in the public hearing from the judge, she goes, I don't like that response. I think he's prejudiced. And she went and filed a motion to disqualify the judge. By filing the motion to disqualify the judge, her actions say, treat me like the debtor. Therefore, disqualify my asset settlement, and I agree to allow you to do that. Do you understand what's happening here? Now, what should she have done to act in the capacity of the creditor when the judge said everything you've done is of no force and effect? and we're disallowing it, and if you don't have this paid in 30 days, you're going to jail, or we're going to garnishment, or we're going to collection, or you're going to be back here for a show cause for contempt. How do you respond to that? Do you argue the facts in what the judge has done? Or do you have to go to pleadings and put in a counter-contractual offer? Because the judge is just making you the offer. We don't like what you're doing.
Couldn't I just do it orally and say, I conditionally accept your position upon the condition that you provide a proof of said claim in the form of an affidavit signed under penalty of perjury? If you cannot provide such proof of claim, then you are agreeing that you have no claim, and thereby have agreed that this matter is been settled, and therefore will be issuing an order for the discharge of this case. Is there any objection to that?
That's one way to go. Or do you understand trust law? You say something like, I conditionally accept that you're rejecting the offer of the surety on the private side whose record appears in this case on proof of claim that by my appointment now of you, Mr. Judge, as the trustee and the banker in this matter, to set off and settle that claim that's before the court, you're not going to assume personal liability if you do not set that claim off. You've just made him a trustee. What happens if the trustee, who's got a public office, doesn't perform his duty as a trustee? He is going to be assholes and elbows running out of that room. Do you understand? Then when he's gone, say let the record show he must have accepted the appointment to carry out the task because I have heard no objection or counterclaim. You understand the authority and the power you have if you act like a creditor and stop arguing with these people and stop charging these people. That's what debtors do. You've got the authority to win your case. You've won it 100 times, and you do not know how to counteroffer these people to bring your win back on top. That's what Gordon is teaching you how to do by contract law. You win this case 100 times, and you still shoot yourself in the foot.
All righty, creditors. No defenses, no excuses. And again, look at where this applies in personal life. How often do you make excuses and defenses?
But
as the debtor.
But.
Creditors solve others' problems. In fact, creditors don't even have problems.
You know, it's an interesting definition for problem. One of its definitions is a question to be solved. When you put it in that perspective, it might give you a little different view of how to deal with it. A problem's merely a question to be solved. Don't you like puzzles? You've been doing them all your life as a kid. These are big kids' puzzles. Problems.
And debtors seek to solve their own problems because debtors see that they have problems. When the IRS approaches you with a $5,000 frivolous filing penalty and you see it as your problem, you're a debtor. When you see it as an accounting problem for the IRS, now you're the creditor. And you can assist the IRS in solving their accounting problem.
You know, I had one of the students up in Wisconsin, and he had done a private administrative remedy over a particular retail item, a $20-some-odd thousand item. Did the administrative remedy. Pretty soon the bank drug him into a public forum, and he calls me up. He says, Gordon, I got great news. I says, what's that? He says, I've been invited to go to court. I says, what's so good about that? He says, well, I get a chance to learn how to do this on a lesser item than my home. But the bottom line is, he embraced it as an opportunity to learn. And he didn't fear the problem, is what I'm indicating. Don't be afraid. Everything that comes at you is an opportunity for you to learn. And what is the value of learning and knowledge? Proverbs 3:13 through 18. Happy is the man that findeth wisdom and the man that getteth understanding. For the merchandise of it is better than the merchandise of silver, and the gain thereof than fine gold. She is more precious than rubies. And here it is. And all the things thou canst desire are not to be compared unto her. We were talking a little earlier. Do you want the gold or do you want to learn how to be the goose? That's an easy one.
You know, a lot of people also appreciate the spiritual side of things that we try to bring to this. And Gordon just quoted a verse from Proverbs. Everybody tends to understand that the Old Testament is not the gospel, the Old Testament is the law, but colorably, the gospel appears all the way through Scripture. In the book of Proverbs, you are introduced to the concept of knowledge. Then you're introduced to the concept of wisdom as another word. Then you're introduced to the concept of understanding. Do you understand that knowledge is raw facts? It's legislative. That wisdom is executive. It's putting the facts into motion. And understanding is judicial. It's being able to show that the knowledge and the wisdom are in harmony. Knowledge is a representation for God the Spirit. He brings knowledge. In the room after Jesus' resurrection, did not the Holy Spirit be sent? And he appeared in the form of tongues of fire on the heads of the disciples and others in that room. And he brought them knowledge because they could all speak in a language with words that they never understood before. So the Holy Spirit is knowledge. Wisdom, being executive, has to be an action in the living world. And God had to appear in the capacity of a living man in order to carry out his job in terms of the executive or administrative side. So Jesus is the personification of wisdom. Jesus showed up and he said, I did not come to judge you. I came to give you life. Who is the party in the three heads of God who becomes the judge? It's God the Father at the white throne judgment in the book of Revelation. So in an Old Testament book of Proverbs, we're introduced to God the Father, God the Son, and God the Holy Spirit, all through the personification colorably of the words dealing with knowledge, wisdom, and understanding. And what was the quotation of that verse again? That joy comes to one who is what? What was the verse you quoted in Proverbs?
3:13 you're talking about? Happy is the man that findeth wisdom and the man that getteth understanding.
Wisdom is finding Jesus, the Savior, for your debt of sin. And happy is the man that gets understanding. That's the judgment of the Father at the white throne judgment that puts you into the no commercial nature once again. Everything that's going on in Scripture is a colorable lesson in commercial understanding in terms of Scripture. It's there in front of you.
Creditors are rational and reasonable. Debtors are irrational and belligerent.
I am not.
Creditors honors contract. Remember we were talking about honor and dishonor, and guess what debtors do? They dishonor. Creditors, this is my own little piece, are aware awake, and present? Are we aware, awake, and present?
Are you conscious? Go to Webster's. I got a good definition of conscious. Awake to one's surroundings and identity. That's kind of interesting. And identity?
Do you know who you are? What is your name? Everything we discussed this morning. So you can't be conscious unless you're aware of who you are and where you come from.
So you're dealing with a society of insane people. How many of those people out there are conscious for reals? How many know who they are? An interesting concept, isn't it? Quit trying to get remedy in an insane world.
World of the dead.
Creditors are in service to others. Debtors are in service to themselves. Creditors are proactive. Debtors are reactive. Creditors are humble. What do you say about going low?
Mm-hmm.
Gotta
You gotta go low to get high.
Gotta go low to get high.
You know,
Debtors
more people
proud and insolent. Insolent is like contemptuous. So, how often do you feel yourself being contemptuous or prideful and proud? It's a very powerful concept to be able to be humble in the face of circumstances. Creditors are forgiving and tolerant. Debtors, unforgiving and intolerant. Are you tolerant? All religions, cultures, people, positions. Creditors are generous and unselfish. Debtors are greedy and selfish. And that's a direct link to being in service to others or being in service to yourself.
Let me ask you a question here. You know, you talk about being tolerant or intolerant. How many people in here are familiar with Pastor Tony King? Most everybody? Okay. Remember that Pastor Tony King suggested way back when that part of his ministry was going to take people to the goal that he was shooting for back in June. Did that happen? No. And then there was a suggestion maybe you were going to get to that goal in August. Did that happen? No. And then time has gone on and on and on. As more time went on, what was the internet buzz with respect to Pastor Tony King and his missions work? Was it favorable to Pastor Tony King, or was it totally critical of Pastor Tony King? Critical. Well, was Pastor Tony King ministering to creditors or ministering to debtors? He's ministering to people that would be creditors. The goal under Pastor Tony King was to get in control of an estate that belongs to you, not to the government. But the government has been controlling that estate under the presumption that we are all debtors and we're incapable of controlling our estate. And under trust law, the government must protect us from ourselves and control our estate. Now, if you're to get to the goal that Pastor Tony King was laying out, why would you be entitled to or have the authority to get to that goal? Would it be because you're demonstrating that you've accepted responsibility to be a creditor and can receive your estate because as a creditor you're competent to handle that? Or is the goal to bring a bunch of debtors in and have them take over an estate in which by being debtors they're defined to be incompetent? You understand what the issue is? And so I'm saying to myself, Pastor Tony King could have taken us all in right away. But the issue is, if you're going to go in and get control of your estate, the one that the government is managing for you, shouldn't you demonstrate to the party that's holding the trust for the benefit of the beneficiaries who are presumed to be incompetent? Shouldn't you be required to show competency such that the trustee, the government, is going to say, well, it appears as though this beneficiary is now competent to handle his own affairs, so we will release the estate to the beneficiary, i.e. the party that's just come in that's demonstrated competency. How are they going to test you for competency?
Are they going to release
Is it everything that Brandon showed on the previous slide and on this board? Traits of a debtor versus traits of a creditor. Aren't they going to assume your communication, your acts, and your actions, and they're going to be giving you a grade as to whether or not you fall in the competency category or the incompetency category? And if you appear to be moving along this program that Pastor Tony King has been projecting at us, then based on your acts and on your actions, you will either be deemed qualified to be competent to receive your estate and control it, or they will deem you to be unqualified because you do not demonstrate in your life the role of competency. Can you see that? And isn't one of the main issues tolerance and forgiving? Why do you think this process of getting to Pastor Tony King's goal is being stretched out in time? Because it's just another test to see whether you are a party of competence as a creditor or a party of intolerance and incompetent, and you're only there for whatever a debtor is there for. Give me the money, and I have absolutely no traits. As a creditor, my intent is not to go serve my brother, just like the movie says, show me the money. That's all you're interested in, and that's all a debtor is interested in under greed and selfishness. Every time in your life, these traits are coming up, and you are being tested to determine whether or not you are dealing with something in the mind and the heart, or whether you're dealing with something that would come out of a debtor. And a lot of the criticism that PTK is taking deals with traits that are coming out of debtors, which demonstrate those individuals do not have the standing and capacity to get the reward to which a competent party should be entitled, because they are proving their incompetence. That's what's happening to you in every one of your commercial cases. The judge is not there as your enemy. The judge is there to test you as the referee to see whether you qualify in merits as a creditor or whether you do not pass the meritorious standard because you are a debtor and you do not qualify to be competent enough to handle your affairs as a creditor. Not everybody in life qualifies to be a creditor. If you look at the Old Testament, you see that the first king of unified Israel was Saul. But you see, during the time of his kingship, Saul was never trained to be a creditor. When he started his kingship, he did very good to begin with for the first couple of years until problems started coming to the office of the king. And when problems started coming to the office of the king, how did King Saul react? He reacted as a debtor king. He blamed David for his failures. But look at David. David was the second king of unified Israel. There were only 3. And David said he was going to be king, but there were years between the time that he was informed he was going to be king and the time he became king. What happened to David during those period of years? He was trained how to be a creditor. How would a creditor react? Don't blame Saul for your problems, David. Saul is your teacher. He is bringing you grief because Saul is not a creditor. You're being given an example of how not to be when you're a king. Learn from your enemy and learn how to be a creditor in the service of God. Learn how to do it right. We're going through a lot of hardships right now, not because our Father hates us, but He recognizes that you people were trained to be debtors. And He wants to turn you around and train you how to be a creditor so that when you come into the gift that He's got for you, you will know how to use that gift as a creditor in His service instead of using that gift and screwing it up as a debtor like King Saul did. That's what it's all about. These are extremely important things to understand in terms of how you're going to succeed in your life if you're going to be the servant and be the creditor that God wants us to be. Third king was Solomon, and after that the kingdom was split. The fourth king is Jesus of unified Israel and all the world. Every other king is an imposter.
As you consider being a creditor, taking that on, consider the benefits. It's all for you. That's why. Your way to the greatest wealth and that everything be added unto you is to adopt that attitude. So in a sense, you can look at this as a very selfish or self-aggrandizement is idyllic because you're going to get it all. So there's a reason for you to act like the creditor, not just simply because of some altruistic reason, but actually it functions very well on a selfish basis. It's a win-win-win all the way around. Become a creditor as opposed to a debtor.
I have faith we will make it through the slides before the break.
Remember, Brandon, the slides
That's also a trait of a creditor, faith.
The slides are just the written side. The reality is what and who we are.
Exactly. But I have faith that we will get through the slides that we should get through before the break. Creditors are unattached to being right. Debtors are very attached to being right. Debtors also like to make others wrong. I would say creditors are unattached to making anyone wrong or being right. Creditors acknowledge others' views. Does it mean you agree? Debtors make others wrong. Creditors put the best construction on all conditions and situations rather than thinking and acting from worst possibilities. Creditors are faithful, and I mean that in the sense of having faith, and joyful. Guys, life is wonderful. It is beautiful. It is the most amazing thing. And if you approach each day with that attitude, no matter what your circumstances and situations, you can create the most amazing things. Debtors, fearful, sorrowful. I mean, there's a lot of fear being manifested in the world today. Fear of the economy, fear of swine flu, all types of ridiculousness, all things that you have no reason to fear.
As you know, social control is best managed through fear. So if you think it isn't just artificially manufactured, give it some serious thought. However, to the unconscious, that's probably the best thing for them, to always be fearful, because that's how you get them to do things they ought to do on their own without acting the creditor.
Absolutely. It's probably because they lack faith and joy, that they need to be controlled through their fear. If you have faith, there's nothing to fear.
You know, faith is an interesting word because, it's in the scriptures a lot, but faith, faith is also defined as loyalty. You get into loyalty and it eventually distills down into duty that you owe, either to man or to God. So if you want to increase your faith, simply increase your compliance with either the rules of God or the rules of man. Of course, the latter won't bring you much happiness. However, the former, under God, to increase your faith is simply to increase your obedience to your brothers and sisters, i.e., enhance your creditorship.
Be an honor in the law. Law is contract. Creditors, composed and peaceful. Debtors, agitated, hostile. I got a great story. I faced some very agitated and hostile individuals. And I maintained my composure and peacefulness. And I remained the creditor in control of the contract. Creditors are author of the experience. Debtors are victims of the experience. Are you responsible for what you create? Are you blaming others? Am I the author, creator, or am I the victim? Creditors are sovereigns, leaders, and masters. And I don't mean masters in the sense of having some sort of physical control over someone else. I mean masters of their lives, masters of their state of being, masters of their conditions. Debtors are subjects, followers, and slaves. Creditors are about what is. See, the tendency of human beings is to give things meaning under assumption and presumption. So someone comes to you and they say something or they act a certain way and you make assumptions and presumptions about that person. You're making it up. When you come from a place of what is and stop being meaning-making machines, because that's typically what human beings do. They go around giving things meaning. So you take maybe the way a person dresses, maybe the way a person speaks, and you make something up about it that's judgment. It puts you in the role of a debtor. Beware of assumption and presumption. Creditors, in the now, in the experience, in the experience. Debtors judge the experience. What do I mean by that? In the experience and judge the experience. Or, you want a microphone? It was rhetorical, but go ahead and answer it. Yeah. What is in the experience versus judging the experience?
Is this on? Okay.
Yes.
One is psychedelic, and the other is observing what's happening. So like maybe being in the stands of the experience versus actually being on the court and in the game.
You could see it like that. When you're in the experience, you're not judging what's going on in the experience. You're just a part of it. So, for instance, if somebody's speaking, and they may be speaking from the heart or they may not, but if what I'm focused on is making up things about what they're saying, I'm totally missing what's really being said. I've spent time with people and listened to them speak on something, and I've heard much deeper than what's coming out of their mouth. People are easy to read. And when you're in the experience and truly connecting with the person, it's a totally different reality than judging the words coming out of their mouth. And you can see much deeper. Recently, a client of mine, he was over at my house. We were working on a process. And I was being in the experience with him. And he was talking about certain things going on in his life. And I saw through the words rather than judging them. And I saw a lot of pain, a lot of suffering around his personal relationship. And I got off topic and started asking him questions about his relationship with his wife that he had been married to for 30 years. And he started to really open up. And he started to really become aware of what was really important. He had been putting all this focus in this process. And in the process, he was having his heart broken by not addressing what was really going on and what was really important to him. And this is interesting because we kind of just abandoned the process at that point and really just had a very heartfelt conversation. And this is a genuinely an incredible man, one of the best men I've ever met, and just a great joy to be around. And being able to give him a peace of mind in his hour of heartbreak was a wonderful experience for me. The next day, he was meeting me at about 2 or 3 o'clock in the afternoon, and he never made it. And I'll never see him again. His broken heart took him somewhere else. So keep that in mind.
To be in the experience is to be active or activated. To be judging the experience is to be passive and critical. So in the one you're participating as a live son or daughter of God, in the other one, you're just reacting instead of acting.
Absolutely. Creditors, maintain authority. Now, that's a skill. Debtors, they grant their authority to others. Very complacent in being subjects and slaves. Creditors are author creators. Debtors are victim destroyers. Creditors control their property. Debtors are the beneficial interest owners of their property. What was it Rockefeller said about ownership? Own nothing, control everything. Creditor has no concern about having title and names on his property as far as ownership is concerned. He is mostly concerned in having the paramount security controlling interest in property, not necessarily the beneficial ownership interest in property. Creditors promote unity. Now, this is a very, very important subject to me because I look at nationalism, USA, or allegiance. I'm a citizen of this and I'm a citizen of that. I'm a part of this group, I'm a part of that group. That group is bad, my group is good. We should be looking more at our similarities than our differences. You need a microphone now too? The benefit of the audio community and video community.
Best stated as creating opposition. Not that that's a position, rather than promoting division, because it's an unconscious promotion versus a creation.
Yeah, if you focus on division in any way, this is my country, this is this is whatever. See, to me, one of the poisons of our world is nationalism. I wept when I saw this country's reaction to 9/11. It was a very nationalistic type of reaction. It reminded me a lot of Nazi Germany and how poisonous that is to the world.
Because I believe
just an idea, just a concept, but I think a very important one to at least acknowledge.
I accept that. I'm looking to see where the unconscious creation is occurring, not out of the proactive promotion. Because I would say that
I can't hear you.
There's an unconscious creation that occurs when people are taking positions, which you've already discussed, that cause opposition versus the proactive promotion of division. Both are aspects of coming from entitlement as a debtor in the world. At least that's how I see it. It's not necessarily a view or a position. I just wanted to put it out there for people in the room who may be struggling with the concept of promoting division, because they may still be coming from a debtor's position but not actively promoting one position or another. It's more of an unconscious creation of opposition by their way of being.
Okay.
Because I see one as consciously promoting and creating, and the other is sort of an unconscious creation.
Okay.
Thank you.
Hold on. Wait for the microphone. Run, Deepak, run.
I'd like to go back to that being in the experience and what we're gaining from being in the experience, and that is power. And that goes to something Gordon said from Proverbs 24-5, knowledge is power. The antithesis would be Hosea 4-6, my people are destroyed for lack of knowledge, which is power. And then you go to John 8:32, in the end you shall know the truth, and the truth shall make you free.
And when you have power, there is no need for force.
You know, under this concept of promotes unity, you can promote unity in an illusion or a bad deal, and that's not what Brandon's talking about here, because if you're promoting unity as it applies to creditors, it's everybody agreeing on the good and the ultimate reality and truth. You could promote a unity in a very bad concept like Nazism or something like that, and that's not what we're talking about here. So that if somebody is attempting to bring parties together, like Pastor Tony King attempted what I almost claim is the impossible, trying to get the diverse ideals under the concept of patriotism to come together with a unified result, because not everybody that's studying the concept of the patriot movement is willing to apply a lot of these principles of a creditor and to be able to move away from their assumptions and presumptions which really make them debtors. But this concept of promoting unity when it's toward looking for the truth doesn't mean that you want somebody just to agree with you. You want to bring unity of purpose to bring them into your association and your company so that you can run ideas off of each other so that we can all learn from each other to find what becomes workable, what becomes the ultimate traits and ideals of a creditor, and to bring us into unity of purpose of trying to help someone else. And that's what we're talking about here. Those that promote division don't even want to get together and learn from others. They just want, through their selfish purpose or reason, to promote their own ideas like I'm the guru and everybody else is not. And so you can see that just promoting unity in and of itself, when the unity is not directed toward the principles of being a creditor, is not what we're talking about here when we're talking about promoting unity.
It's about loving thy brother and thy sister unconditionally. Creditors live in the now. I've pretty much explained that over and over. Debtors live in the past and the future. They like to drag their past around with them and drag your past around, bring it up, and throw it in your face. Ooh, natural law. Those of you who are in Chicago remember I did our little natural law approach with Western religion, and I brought the 10 Commandments in. This time, I'm going to do the same thing, but instead of using Western philosophy and religion, I'm going to go off of the fourfold noble truth and the eightfold noble path. 8 and 4 are 12, and this is a beautiful truth as far as I'm concerned. Life is suffering. What causes suffering? Attachment and desire cause suffering. Is that to say we should be without attachment and desire? Only if you seek not to suffer. It's not right or wrong. It's the beautiful thing about this truth is it's not telling you to do anything about it. It's not saying you're wrong if you suffer. It's not saying you're wrong if you desire or you have attachments. I am very attached to my children. It's very hard for me not to be attached to my children. fourfold noble truth number 3. Cessation of suffering is attainable. It is possible. It is possible to eliminate all attachment and desire. Is it right or wrong to do so? No. You can. You don't have to. And I believe the term for that is what? Nirvana? Liberation, nirvana. Fourfold truth number 4. Path to cessation of suffering. Now, this is kind of like the path of, not of eliminating it necessarily, but of moderating it. You've heard the saying, everything in moderation. I'm a big fan of the middle way. And the middle way is don't take a position, don't look at the extreme. You guys have heard, maybe, I don't know if any of you have downloaded the classes, but you've heard me talk about the genius and wisdom behind South Park. Jack does his movie reviews, and I'll review South Park episodes. And there is a level of genius there because they're always on the middle way. They're showing you the ridiculousness of taking a position on any side. I think that's the genius that they carry in those stories that they put out. So let's look at the path. This is the eightfold noble path. Right view or thought. And it's not right in the sense of right or wrong. If you're a Mason, this would be square view or thought. Your thoughts are very important because from thoughts will come your intentions. From intentions will come your speech and what you say. I know if you've downloaded the classes, you've heard, I think one of the most important aspects of everything we do is how we speak. I am very much a fan of linguistics and language and how we use it. You must be mindful of how you use your words, especially in being a creditor, both in relationship and in courts and in commerce. The words that come out of your mouth will very clearly show your intention. And your intention is very much a reflection of your views and thoughts. Number 4, right actions. Thoughts, intentions, and speech lead to conduct and actions. And what did Jack say about conduct and actions and how important they are? It's not what you say, it's what you do. Now, what you say is important, but it doesn't show as much as your conduct and actions what your intentions are. There's a person who's close to me, and this person likes to put on a great image, to show the world. And so this person, when they speak to people, they put on this kind of, happy, cheery, like, I like you, you like me kind of thing. But their intention when the people that they do this with aren't around, they talk very negatively. They hold a very strong opinion against. They judge people. But they think because they talk that way that they can make friends and people will like them. And guess what? Very few people do. Because they see through your speech and your actions straight to your intentions. Right livelihood. When you have clear thought, intention, speech, and actions, you can put that to use in your work. And I don't mean your job. What's your purpose? Why are you here? How do you conduct yourself? All of it comes back. Right effort. Right mindfulness. Coming back to consciousness and awareness. Are you present? Are you here? Are you awake? And right concentration. Maybe I could say focus. Now, the first three, or first two, we'd classify as wisdom, or group as the elements of yourself that come from wisdom. Second three, your speech, actions, and livelihood, deal with ethical conduct. And the last three, I would say, are about development of your awareness. Now, I've classified this under natural law. If you use these principles, are mindful of these principles, and are truly aware of how you're acting, how you conduct yourself, how you speak, this may be the most important thing in getting out of your state of suffering, or at least bringing down or limiting the level of suffering you have in your life and the suffering of others. Think about it. Does your thought, intention, speech, and action, livelihood, effort, mindfulness, and concentration, can that not affect how others react, especially those who are unconscious and unaware? Do you not affect those around you? Do you not have the capacity to make those around you suffer? So, something to consider. This is my little different approach rather than using the 10 Commandments on this one. Because there's truth in both approaches. And there's guidance for us to use and utilize in our lives. 5? Okay. Oh, look at that. Well, it's 5 minutes to lunch, so seeing as we've come... Actually, do you guys have anything for the next 5 minutes? Any comments? What?
I think perhaps you might sum up most of these things in a little book that you've all, many of you, been counseled to get a hold of, which is As a Man Thinketh by James Allen. And those passages within that book probably would encapsulate most of all of this, and then some, giving you that rudder to govern your life by and produce results that are going to be most pleasing to you. Because the bottom line is, you want to be productive and produce results.
Absolutely.
I have a friend that suggested that you have one of two choices to make in life. You're either going to lead your life under the concept of love, which deals with the creditor, and this in my dual trust chart, the land above the line, or you're going to deal in your life with the concept of law. where you're trying to fulfill some kind of law. That sounds good on the surface, but remember, in the spiritual world, we're unable in and of ourselves to fulfill the law. And we also know in our commercial society as it exists today that the law that exists in their courts is the law which is called statutory law, and we are physically unable to perform everything that exists under that statutory law because it's so large in volume that it's physically impossible to read it and know it. And if you violate that law, it's fundamentally you're unable to pay the penalty therefore, because in the public sector there is nothing except debt units by which to try to tender a set-off, and a debt cannot possibly pay a debt. So if you're trying to lead your life by fulfillment of the law, by your activities, you are unable to do that, and there is no remedy for you. So you have to understand that to be the creditor in your life, you have to lead your life under the concept of love your brother. That's what it's all about. That's what basically Brandon has shown you as the difference between the traits of a creditor who lives his life under love or a debtor who is always trying to control everything by the fulfillment of the love or the law by your capacity. How many people in here saw the movie The Watchmen? Remember, there were 6 superheroes in that movie that were really divided down into 3 groups. The one group really appears to have had no interest in the law in terms of settlement whatsoever. And those 2 characters appeared to be the most powerful man in the world, the one that was represented by the glow, and the wealthiest man in the world, and also the smartest man in the world, which was the one that was directing the settlement or the resolution of the problem that existed in that story. The middle group was a man and a woman superhero that really took no position to the one extreme or the other. They were just out to help people individually. And then the 2 other superhero characters in the movie, one of them being basically the comedian and his friend who narrated the whole movie, which was our hero that was Rorschach. And what was the comedian and what was the Rorschach's personality and goals in trying to direct society? Weren't they extremely directed toward fulfillment of the law and everybody performing under the law? And in the outcome of that story, first of all, the comedian was dead. He had no effect on the outcome. And Rorschach, who was trying to direct the outcome based upon the fulfillment of the law through their actions, was totally incapable of performing that task. And in the whole story that they're telling you on The Watchmen, aren't they really telling you that love and solving the problem is more important than trying to direct your attention to resolving the issue of law, which we are incapable of performing, at least to get a remedy of in and of ourselves? And so it deals with creditors being on the side of love and debtors being on the side of trying to fulfill the obligations under the law, which because of the establishment of the system, we are unable to do within that jurisdictional venue.
All righty, we're going to break for lunch.